Hello, Tessa.
Hi, Miss Archer. How was your weekend?
Oh, too short.
I know.
It went so fast. It's getting like 2020 now.
I know.
I don't know. I don't know what's happening. The days are going so fast.
I know. I went on my trip and I felt like I boarded the plane into the States and I got right back off in Nassau.
Oh, Lord. How was it?
It was nice to get off the island for a little bit. It was a busy trip, but it was still nice to just get a break from work. But
they wearing masks now, these people?
Yeah. It's not as bad. I think the media kind of dramatized it because it seemed like they had a lot of protocols when we were there. Like all the restaurants, you have to wear masks. Any building you go into, like grocery stores or shopping stores, basically everywhere you go, you have to wear a mask. In most of the stores, they actually spray down things when you're using them, or like if you're checking out, they'll spray down the surface between each customer. They spray down the grocery carts. So it seems like they're doing okay.
They were not doing that when I went in November.
Really?
None.
What area you went in?
I went in Miami and I went in Fort Lauderdale. They were spraying nothing. There was no spray for you to wipe your hand. Nobody was wearing masks.
Man, I was in Fort Lauderdale and then we drove up to Savannah for a few days to visit family. But Savannah, I think was worse than Fort Lauderdale. There was less people wearing masks in Savannah than in Fort Lauderdale. At least the area we were in. Yeah.
No. I know the restaurants were closed in November. Red Lobster, Denny's, all of those were closed. Because they said that people who normally would buy food, they didn't have any jobs. And so they had to close. And so really there was nothing to eat.
No, we didn't have that problem when we went. I guess because of change, maybe they had some changes, but all the restaurants that were open, they mostly did outdoor seating. They had some indoor seating. And then they would like, you had to spray your hands when you went in and different things like that.
They wasn't doing no spraying. None, no wiping of counter, none. Wow. It was so scary. We ran in and ran back out. I'm serious. We stayed in our hotel room. Besides, like going to the mall, we went parked to the side where the door would be, run in and run out.
Yeah, we didn't do much shopping. We did most of our shopping online. We just got a couple of things because obviously with COVID, you want to watch your spending, but we just did a couple of things online. And like I said, we mostly just went over to see family. So it's not like we did anything extravagant.
Okay, yeah.
Kept it low key,
But I know it's scary. I can tell you that. It's scary.
Yeah, I think it's important to be careful when you go. Just make sure you wear your mask, even if they ain't wearing it. Make sure you wear yours and have your spray or your sanitizer with you, and constantly. Like I know I like the hand sanitizer sprays, so I would just keep spraying my hand wherever we go and making sure you're not touching your face and the usual stuff.
That's too much consciousness.
Yep.
Nah, I don't like it.
Yeah, we're hoping to do some more domestic travel, but obviously some of our family are away and we haven't seen them in over a year. So I said we figured we might as well go and see them.
Okay. Well, at least you enjoyed it.
Yeah, so it was a nice break for a couple of days.
Yeah, to get off the rocky.
Yes. Yes.
It ain't that bad.
It's not, but sometimes after a long period of time, Nassau can feel small. It's good to get a breather. Mind you, by the time the end of the trip was coming, I was like, I ain't ready to kind of get back home.
Yeah, you wanted to come back to that rock, right?
Yeah. Every now and then you need that little step off and then you step back on.
Okay. So it's 6:09. Last week we waited until 6:30 and they only had 1%.
Oh, wow.
So you're the only one, and I'm going to get ready to start so they can actually listen to the recording.
Okay.
Yeah.
I saw an email where it said it was postponed last week. I know I had told you I was
Right.
traveling. I had to make it, but we were still on the road that night and I couldn't get the internet, the hotspot to work in the car. So
No, I remember you said that you'd be traveling, but all the other ones didn't come. Only person came was who was it?
Was it
I
Danielle?
can't. Yes, Danielle.
Yeah.
It's the only one. Okay, so
I mean,
let's start.
I know that they had said that they were thinking about switching days. Is there a different
Yeah, but
day?
Miguel came back and Miguel said students say no, they prefer the Monday.
Yeah, Saturdays didn't work for me. I was wondering if there was another day during the week that might be better for everybody.
But we're almost to the end now, so we might as well finish.
Yeah.
And I said, this time it's being recorded, and so they'll just have to listen. So did you have a chance to read the chapter on investment?
I read the chapter on the investments and the icon. So I reviewed all of that and reviewed most of the legislation. Some of it is, there's a lot of different amendments. I tried to read the ones that had most of the information that was relevant.
Right. So what they did was they revamped the whole investment legislation.
Right.
The whole thing, the act and the regulations. And what they wanted to do was bring it on par with other jurisdictions.
Okay.
Right. And so when they started out by giving you a definition of what is an investment fund. And they try to make it more diversified. So more people will be interested in coming to the Bahamas and actually creating funds or investing in funds that are here registered here.
Okay.
So they say an investment fund is a unit trust, a company, a partnership, or investment condominium, that's the icon, that issues or has equity interests, the purpose of which is to pool the investors' funds with the aim of spreading investment risk and achieving profits or gains arising from whatever it is that the fund is supposed to be doing. So it could be doing acquisition, it could be doing just holding assets, it could be managing something, or it could be disposal of investments. So the whole thing about investments is a pooling of funds. And in the act, it tells you that to carry on the business of investment fund, you have to be licensed under one of the four. So either it's a professional fund, a standard fund, a smart fund, or a master fund. So professional fund is for sophisticated investors, and they could be offered to the following categories of persons. So a licensee under the central bank, the BTCRA, a broker registered as a securities investment advisor under the Securities Industry Act. I noticed they have to maintain a capital of 120,000.
Yeah.
Or a broker dealer, or a firm of investment advisors, an insurance company, an investment fund that is licensed, or a pension fund, where there's a professional investment fund manager. So notice that for the professional fund, you have to be more or less a professional. It could be a natural person whose individual net worth or joint net worth with their spouse is over $1 million. Any natural person who has an individual income above 200,000 or joint income with their spouse of 300,000 in the past 2 years, and any entity in which all of the equity owners satisfy any one of the foregoing requirements. Hi, Danielle.
Hi, sorry I'm late. I thought class was
That's okay.
postponed.
Oh,
And then I left work late, so I'm a little bit
okay.
disoriented. Sorry.
That's all right. That's all right. We just started. We're going over the 4 funds, the 4 categories
Okay.
that you have to be licensed under. So the second one is a standard fund. This doesn't satisfy the requirements of a professional fund or a smart fund. So the smart fund is the one that a lot of the offshore banks use, where they have the 7 templates that are already pre-approved as to who can invest in each level of the fund. So you have Smart Fund 1. That's where the financial institution has a discretionary management agreement and it sets up an investment fund with such customers which would meet the requirements of the template. Then you have the two, and that's why you have no more than 10 investors, and investors have to qualify to be a professional fund. Smart Fund 3, this is the one that they brought about to replace the exempt fund. They created an exempt fund under the repeal of the Mutual Funds Act. This one is 15 investors, and they could continue to carry on the business as an exempt fund for the prescribed period in the act. The Smart Fund 4 is no more than 5 investors. An investment fund operates as a private investment company, and that's normally for family businesses. 5 is no more than 5 investors, and they hold equity interest in the fund. Each investor is a profession. Each investor in the fund is a person to whom a professional fund may be offered. It operates as a private investment vehicle, and the fund has an administrator. And that administrator is a financial institution. 6 is having no more than 5 investors. An investor, the fund is a person to whom a professional fund may be offered, and they hold equity interest in the fund. And then Smart Fund 7, which is the super qualified investment fund. A single investor may be permitted. Maximum number of investors is 50. Minimum investment of $500,000. And the administrative function can be outsourced to another jurisdiction. Asset managers could use the Smart Fund 7 for assets of up to 50 investors, each contributing a minimum of $500,000. And the Smart Fund 7 is also used for private wealth management. What do you think would happen if you invested in a fund, right? You're worth over, I don't know, say $10 million. You invested in a fund, and now you're seeking to redeem your equity in the fund, and the fund administrator is giving you the runaround. What do you think is your next step?
Could you, I mean, and I know there's usually an investment fund manager as well. Could you communicate with them?
You could. What if the fund administrator and investment manager are in it together?
Then you'd have to report, I guess you'd have to somehow report it to like the commission.
To the commission, exactly. But now don't forget, now a lot of these funds are invested in by foreigners.
Right.
So they would know what is the next step. And I always ask students this question: what is the risk to the Bahamas in creating all of these funds to the jurisdiction? Because what happened if the administrator and the manager utilize the funds that were put into the fund? Then what happens?
Well,
That's
doesn't the fund itself have to have a certain amount of liability, like coverage?
Yes.
So in that case, I mean, if they've used my money that I've invested in this fund, then wouldn't the liability coverage be able to pay me back what I put in? I guess I wouldn't really be able to.
Yeah,
say.
but I'm wondering if they advise the investors of this coverage. You see what I mean?
Yeah.
I've invested in your fund. What's my coverage?
Wouldn't you have signed some sort of, they usually sign a subscription agreement. So wouldn't there be certain clauses in there that would outline like what you're investing in, how it's going to be managed, and then I guess how you can hold them accountable?
I don't remember saying that in any, I don't recall that.
What is usually outlined in the subscription agreement? Just what is being offered?
Yeah, what's being offered. I'm trying to remember if I've seen. Don't forget now, when they put these subscription things together, it's not as comprehensive as the ones in the States. I'm trying to see. Okay. I know I've seen a local one. I could tell you for next class, I'm gonna have to read it and see what it says with regard to liability. Because I don't remember liability sticking out.
I remember reading something in the materials that spoke to, what did it say? It said that there's some sort of agreement. Oh, what did it say? Hold on, let me see if I can find it.
Okay, hold on, I'm reading. Now I know they always have that disclaimer. Investors should not treat the contents of the information memorandum as advice relative to investment matters. They always say that they should seek their own professional investors. And let me see if there's any sections on this. Offering summary, directors of the fund, investment objectives, investment restrictions, risk factors. There we go, 10.
You're looking at the 2019?
No, I'm looking at CFAL's Global Equity Fund.
Oh, okay.
Information memorandum. I'm saying, hold on right now. Let me see page 10. 9. Well, they say page 10. But page 10 does not speak to liability. They calling people's names. So it's not that. Okay, so they give you the role of the people. Hold on. The risk is only talking about what they're investing in. Risk management, they say the investment manager has extensive experience in trading both equity and fixed income. No, it doesn't speak. Risk factors. General risk, they have investment objective risk, liquidity risk, and inflation risk. Limited transferability, regulation, lack of operating history, credit risk, volatility risk, market risk, equity risk. Yeah, I'm just wondering what happens.
That is a good question.
Yeah, I don't see it. They have all the various roles, but doesn't speak to what happened. No, so let me see.
I mean, I guess you could look at it like any sort of business that you invest in, or like, and it turns out to be a scheme or like a sham, like a scam, you could then like just report it, and then you'd obviously have to go through all sorts of legal processes.
Yes, and it's whether there's any money left.
Yeah.
That you can get something from it.
Now, obviously, when they're licensed, they have certain reporting to do with the commission. So wouldn't, in a case like that, sometimes the commission might pick up on inconsistencies?
I would hope so. I would hope so. I would really hope so.
They have to file their annual they have to file like their annual financials and stuff.
I have a big question mark there. A really big one. I'm not sure. I'm not sure. Who is checking what, or if they're checking, what are they checking? You see what I mean? Yeah. Like you could send it in, but who's checking what you're sending? Okay, so there's a section on redemption. They just say you can send that in. And how many days you have to wait. And I know there's wait on the calculation of the NAV before they pay. No. I don't know. Yeah, let's go. Self-administered investment fund. This is where the fund is not appointed an external investment fund administrator, but it actually administers it by its own people. So these funds are recognized as regulated investment funds and are required to hold the investment fund license or be registered with the commission. The investment fund is limited to having no more than 5 investors who hold equity interests. And then each investor is a person to whom a professional fund may be offered. The fund operates as a private investment vehicle, and it has an administrator, and that administrator is a financial institution. Then you have a master fund. This is a company or partnership, unit trust or icon that has us as investors other investments or feeder funds. It holds investments and conducts trading activities for the principal purpose of implementing the overall investment strategy of the feeder funds. It has its own investors, one or more feeder funds, either directly or through an intermediary entity established to invest in the master fund. So which one do you think CFAL falls in under out of the 4?
I would think that it's almost like a master fund, wouldn't it be? Because it's obviously, wouldn't it has its investors, other investment funds? Wouldn't it then invest in other funds below it?
It actually invests. I think it has one model like that. Some of the other ones, they just invest in equities. So they invest like in the Bahamian companies when they offer shares and register stock, they would invest in those. And then they have other ones that do invest in other funds, the ones that are outside the jurisdiction.
So which category would that fall under?
The main only thing I could see would be a master fund.
Yeah.
Okay, so an investment fund has to be licensed under one of the 4 categories. And of course, you know, if you don't obtain a license, there is a fine. So to be classified as a professional fund and a standard fund, you must have an investment fund administrator and a manager or an alternative investment fund manager. The unit trust must have a trustee, of course, and a trustee have to be licensed. as an unrestricted, not restricted. You know the difference between unrestricted and restricted trusts?
The restricted, they have a limited amount, and the unrestricted has an unlimited amount.
Amount of what?
Oh, you put me on the spot. I know one is they have like a limited option of what they can, and like what does it say here? Hold on, let me just take a look at my notes. It's in respect of a specific amount of funds that they're allowed to administer, and then the unrestricted can administer for any amount of funds.
Right. So if you have a license as as a restricted trust company, that
Right.
means you're only allowed to have a certain number of clients.
Right.
In most instances, it's not more than 5. Unrestricted means you can have as many clients as you want. And then it says, what else? Okay, of course, they have to have minimum paid up capital, and they must have a reserve of $2 million because that's the buffer, along with insurance. A smart fund must have a nexus in the Bahamas in order to be considered a Bahamian-based investment fund. So where there's a non-Bahamas-based investment fund and it's being administered, the investment fund administrator or the manager has to notify the commission in writing of the fund's nexus to the Bahamas. And then they have the timeline, which is 14 days. And then 14 days if they wish to terminate. So both the investment funds, Bahamian and non-Bahamian, where equity interests are being sold in the Bahamas, they have to file a current offering document of the investment fund. If the investment fund fails to notify the commission that it has changed its principal office, operators, or amended its offering documents, it is not in compliance with Section 10. An unrestricted investment fund administrator can only license investment funds for which it is the investment fund administrator and for which it provides the principal office. It must also satisfy the following persons are fit and proper. That's the promoter, the operator, the fund advisor, the fund manager, the auditor, the custodian, and if they're operating in the EU, the alternative investment fund manager, and the alternative investment fund, what is it? MD. I can't remember what MD is again.
That's what I was going to ask you, because I was reviewing, when I was reviewing this, I kept trying to find a definition for this AIFMD. And I was like, what does the D stand for?
I can tell you in a couple of minutes. I always forget the D. Always. Every time I like, what is the D? What is the
Because
D?
I saw what AIF was. AIFM, Alternative Investment Fund Manager. And I was like, well, what is the D?
Yeah, there's a D. Oh, I know what the D is. Alternative Investment Fund Manager Directive.
Ah.
They follow the directives under the EU. I tell you, I can remember, just that it doesn't flow with the name.
You said Alternative Investment Fund
Manager Directive.
Directive. Okay.
Mm-hmm. They
Yeah,
follow
they
follow the EU Directive 2011/61.
Okay.
So the commission has a right to waive, vary, or revoke conditions placed on investment fund license. They can grant or refuse it. They can also refuse to license an investment fund under certain conditions. So the Act permits a transfer from the Bahamas to another foreign jurisdiction of a regulated investment fund. And of course, you have to notify within 14 days. Alternatively, an investment fund may be transferred to the Bahamas upon notification to the commission, and that's 21 days. My next question is, this whole legislation has been revamped. It's brand new. I don't recall them advertising for more examiners in order to ensure that these new requirements are being fulfilled. Have any clue?
I don't. I haven't heard of anything new happening at the commission, like if they've taken on more departments or what the case is. I know they were very busy this past couple months because some of the items that we've sent into them, we've been getting delayed responses. Now, it could also be because they changed all of their fee schedules as well. So a lot of people, there was a lot of back and forth with people this year on their new fees and payment of their fees. So I'm not sure how they're meeting that.
Yeah.
Because it is a lot to
That's why
review.
it is a lot. And it's a lot for the fund manager and administrator to carry out. It's a lot. So let's look at the fund manager. They have to be licensed or registered. They have to be capable of complying with capital assets and organizational requirements. They have to have sufficient experience. They have to be qualified for the performance, and they have to be of good repute. So you can see just in terms of licensing and investment fund manager, that's a lot of background work you have to do to see if these people, one, not bankrupt, two, they have the adequate experience and knowledge to carry on this job. So licensing of the manager is required where it intends to manage a standard fund or any other investment fund in any jurisdiction other than the EU. Registration is required if it intends to manage professional funds or smart funds. Other than the EU, whose equity interests are offered to accredited investors or is licensed or registered in the prescribed jurisdiction. Licensing is also required if it intends to offer its equity interest for sale in the EU. The license of an investment fund manager is granted if the applicant has sufficient capital, own funds, and professional indemnity insurance. The persons who will be conducting the business must be, of course, of good repute, must have experience, and their conduct is decided by at least two persons meeting such conditions. The names of these persons should be sent to the commission prior to the grant of the license. The shareholders and members of qualifying holders are suitable, and the principal and the registered office are in the Bahamas. How many fund managers do you think we have?
I would say probably, I would guess a lot. I think from when I saw the most recent one from 2019 was 60. I think that's it, 60 investment. Hold on, let me look at that. I know you can find a listing online. They usually
Yes,
keep
you
that pretty
can.
maintained.
Registrants, go to registrants.
Let's see.
Let's see. Investment
Now,
fund.
in most cases, our investment fund managers and administrators, they're typically companies or is it like pretty much 50-50?
No, not 50-50. No. Because administrators, we only have how many? Administrators, we have about a lot.
Hold on, let me see if I could find a listing.
The listing of administrators, there is, let's see, on an average, I'm just gonna count how many on one page. So on one page, we start from 8, we have 1, 2, 3, 4, 5, 6, 7, 8. We have about 8. And there's 7 pages. So 8 times 7. That's how many fund administrators we have and their companies. Now, when it comes to funds, they have hundreds.
Yeah, I know there's a lot of those.
There's a lot of funds. And administrators are on the side.
Oh, yeah,
So
I
the
see it.
investment fund
Administrators.
appoints an administrator. And the administrator have to be licensed. It either could be restricted or unrestricted. And the company could be incorporated under the Companies Act.
This is the investment fund, you mean?
The investment fund administrator.
itself. Oh, the administrator.
The administrator. Notice if you look on the list, administrator, Amacorp Fund Services, BAF Financial and Insurance Bahamas, Britannia, Keystone, CFAL, not that many, CIBC Trust, not that many, Citco, Colonial Pension Services, Credit Suisse, that's almost a page, Deltec Fund Services, almost a page, EFG has 2, Equity Bank and Trust, but quarter page, FitPart Fund Administrator, Fund Haven. So there are quite a bit of Genesis Fund Services, Intertrust Bahamas. So you see some of them are unrestricted banks and trusts.
Right.
And some are restricted. So every year in January, they have to renew their license and they have to keep the register. The fund is required to maintain reliable accounting records and should be kept for a minimum of 6 years from the date of the transaction. Let me ask you a question. If you create a fund and you put assets in the fund, should those assets be liquid?
You mean like able to move around?
Yeah, actual liquid.
I
You can
would think
invest
so,
in a
because
fund and
that's
you
how
get
you would want to
shares.
keep them invested, and you can keep moving them to make sure that you're spreading the risk. If you can shift them around as needed. Wouldn't be stuck.
I'm just anyhow.
What's your thought?
I'm just wondering if you create a fund, you invest, you create a fund. A fund is created for you by a fund administrator. You invest and the fund is created for you alone. So you own the shares in the fund. But there are no assets, no liquid assets in the fund. The question is that a fund? Because a fund's supposed to have assets and assets that you manage so that you get a return on your investments. Just food for thought. And it says that the investment fund, the manager, or the fund administrator has to inform the commission if it wants to wind up, dissolve, or terminate the fund within 30 days. So if you're going to terminate an administration agreement, you have to notify the commission. There's a lot of notification. When an investment fund administrator intends to terminate, it is required to 1, appoint another investment fund administrator upon the expiration of his notice, immediately notify the commission of the appointment of the new investment fund administrator, get the approval for the new investment fund administrator. The investment administrator may dismiss its investment fund administration for the following reasons. It goes into liquidation, either becomes bankrupt or appoints a receiver, or with good and sufficient reasons, they could have a written request submitted by the investors with equity or any other reason. Operators of the investment fund must notify the commission within 14 days. You notice these days are similar to what you see in the Companies Act?
Yeah, they're very close together.
Very close, yes. And I see it being very burdensome on the fund administrators because all of this notification is a lot of work.
Yeah, it is a lot of filings. Now they do make it easy. I think now, especially since COVID, a lot of the filings you can just make online, but it is a lot of notifying the department.
Yes, it's a lot. So, okay, so they say operators of the investment fund must notify the commission within 14 days of the dismissal or appointment of a new investment manager. But then they have to seek the commission approval of the appointment and notify the commission of the particulars of the investment fund manager. And of course, they could request an extension. So one is notification and the next one is approval. That's two different processes. When you seek an approval as a formal application, notification is just a one page. An investment fund fails to appoint, if they fail to appoint a new investment fund administrator and they refuse to accept any new subscription or process, any redemption of shares, its license will be automatically suspended. You know if that's happened yet?
I am not aware of, I mean, I'm assuming it has to have happened before, but I'm not aware of anything that I've come across like that.
Okay. So it says, the investment fund ceases operation, must surrender its license and submit a wind-up plan to the commission within 14 days, or you have a 14 days or the 60 days extension. Issuance, transfer, disposal of shares in investment fund administrator must be approved by the commission. The investment fund administrator must maintain the required minimum capital, and if there is reasonable cause, the commission may request a professional indemnity insurance. So if they are registered under the Banks and Trust Companies Regulations Act, they would already have the professional indemnity insurance. So what are the general duties of the investment fund manager? Well, first, you have to act honestly and fairly. Do we have a lot of these investment fund managers? I think I asked you that question just
Let me
now.
look at that. I think we pulled that
I see
up.
the administrators.
I don't think I saw a listing for the manager.
There's no listing of the managers.
I didn't see one on the website.
No.
I see it for administrator and then fund licensees.
Yeah, I don't see it. So they have to act honestly and fairly with due skill, care, and diligence. They always have to act in the best interest of each investment fund. And they have to employ effectively the resources and procedures necessary to perform. Take all reasonable steps to avoid conflicts of interest. Does not sound familiar to you?
To me, it sounds like either a director or a trustee.
Yes, yes. They've married the two together. Okay, to act honestly and fairly with due skill, care, and diligence, that's the director. To act in the best interest of each investment fund or the investors, which one is that one?
But sorry, you broke up. Can you repeat that for me?
Act in the best interest of each investment fund. Which one is that, the director?
That sounds
or the
like
trustee?
the trustee.
Right. Have an employee effectively the resources and procedures necessary for the proper performance of his business activities. Sounds more like the director.
Yeah.
Take all reasonable reasonable steps to avoid conflicts of interest. That's both.
That's both. Yeah, I was
Yeah.
gonna say.
Comply with all regulatory requirements. That's both.
Yeah.
Depends on what you're doing. Treat all investor fund investors fairly and ensure that no investor in investment obtains preferential treatment. That sounds like trustees. Investment fund administrator must have an initial capital as prescribed and have its own funds or additional own funds which are appropriate. Prior approval is required for an investment fund manager to delegate his function to third parties. What that sound like to you?
That sounds like a trustee.
Yes, it is.
Because they can delegate as long as they make sure that the person knows what they're doing.
Right. The only difference is under the Trustee Act or the Companies Act, you don't go for these approvals. But under the Investment Act, you have to actually go to the commission for these approvals. Prior approval is required for an investment manager to delegate his functions to third parties. So don't forget, under the Trustee Act, as long as the trustee has done his due diligence, then unless one of the beneficiaries decide to bring a suit of breach of trust, then no prior approval is required, unless, of course, there is something within the trust deed itself that speaks to when he's employing an agent and he needs to require the consent of a protector or of the beneficiaries. And again, and think about it, when you read this section, it's so similar. Because I have written right in my notes. Sound familiar?
Yeah, I was thinking that when I read through it that night, and I was going through it, I kept thinking that it sounded like a trustee.
Yes. Ensure that the delegate has sufficient resources to perform the delegated function, that the persons who conduct the business of the delegate are fit and proper. Delegation of functions cannot prevent the supervision of the investment manager, fund manager, from acting or managing in the best interest of the investor. So it is similar to what's in the Trustee Act and what's required of a trustee. The investment manager must not delegate. Again, it's familiar. A delegate must not sub-delegate portfolio management or risk management function to a custodian or delegate of the custodian or any undertaking whose interests may conflict with those of the investment fund manager. And then they said they don't want it to become a letterbox entity where you just ticking things. So it put on the investment fund manager the same onerous duty that a trustee has when he delegates. He has to make sure he oversees all the reports that come in. He has to make sure that he's making the decision always in the best interest of the best financial interest of all of the beneficiaries in the trust as a whole. And in here, they've done the same wording. So, delegation of functions. Notice the next word, an application to the commission to delegate a function must be able to demonstrate the following. So you're going to make an application now to delegate a certain function. And then they're telling you what the requirements are. The delegate is qualified and capable of undertaking the function. The delegate was selected for appointment with all due care. The investment fund manager is in a position to effectively monitor the delegated activity. The fund manager is able at any time to give the delegate further instructions, and the manager is able at any time to revoke the delegation with immediate effect. So when you make that application to say you appointing someone as a delegate, it says you have to have the prior approval. So when you write to the commission, you have to set out that you've met all of these requirements if you wish to delegate any function.
What section of, are you reviewing? Is this a section of the act? What section of the act is that under?
I could tell you.
Or what are you reviewing that from? Just maybe I could.
It's from the act. I have it in the notes. Hold on, let me see if I can find it for you in the section. Oh, I'm in the wrong place. Act.
You're in the 2019?
Yeah. I am looking. Here we go. Can't tell you the section right now. Let's transfer out of the Bahamas. It's page 26. Go down, go down, go down, go down. I'm looking for this delegation of functions. Hold on, let me see. I should have put the section in here.
All right, working you hard.
No, I mean, it's in here. I got it from here. Just trying to see. Uh-huh. Okay, I think I've gone too far. I know it's in here. And the thing about these legislation is they don't have a search.
I know.
They don't have a search. Hold on, let me go back up.
Oh, I
AIF.
see it. Is that section 65, I think? Delegation of investment fund manager functions. Is that it there?
Hold on, I'm at 60 now.
65, 65.
63,
Let me highlight that
64.
section.
Yep, that's it right there.
Great.
Mm-hmm. So that's 865, subsection 3. The investment manager must be able to demonstrate to the commission that
I see.
the person is qualified and capable. Section 65. And then the one where I said before that, when I said that they can delegate the function to third parties. So that's section 65, subsection 2. So custodian. The fund has to appoint a custodian who is independent of the investment fund administrator and the manager and operator of the fund. The custodian obligations are to ensure that the sale, the issue, the repurchase, and the redemption and cancellation of equity interest of the investment fund is carried out. The values of the equity interest of the investment fund are calculated. The instructions of the investment fund manager are carried out. In transaction involving the sale of the investment fund's asset, any consideration is remitted to the investment fund without delay. An investment fund's income is applied in accordance with the Act, the constituted documents and offering documents of the investment fund, and the law where the fund is authorized or established. The custodian must hold assets or cash held for the investment fund separate and apart from the property of the custodian. Now then they just go on to talk about the AIFM, the Alternative Investment Fund Manager. So an alternative investment fund manager can appoint an internal or an external AIFM who have to meet all of the requirements of the commission. The alternative investment fund manager should have an initial capital as prescribed by the commission and additional own funds which are appropriate to cover the liabilities arising from professional negligence or professional indemnity. The commission will provide the status of the alternative investment fund manager once the requirements of the act are satisfied. Then alternative investment fund manager must adopt sound administrative and accounting procedures, control and safeguard arrangements for electronic data processing, and have adequate internal control mechanism. Similar to the duties of an investment fund manager, the alternative investment fund manager must at all times maintain general operating conditions. They must establish and maintain remuneration policies and practices for persons whose professional activities have a material impact on the risk profile of the alternative investment manager. So this term, alternative investment manager, is new. It was not in the last legislation. Why do you think the commission decided to put in this whole section on the AIFM?
I mean, my question is that it's kind of like an alternate director where if one can't act, then the other can act in their place? Or is it not? Or do they act together?
I know when they introduced it, they were saying that this is to meet the requirements in the EU. So normally the alternative investment manager is a company or an IBC, and they market their fund in the EU.
Oh, okay.
Yeah. And these changes, these well, not changes, these additional provisions were put in to address where funds were being marketed in the European Union to meet their requirements. So you have an investment fund in the Bahamas, and once it's outside, then they call an alternative investment fund. Alternative investment fund manager. Alternative investment fund manager, D. That means a directive, 2011. So an AIFMD custodian may be a bank or trust company licensed under the BTCRA, or a person registered under the SIA, or any other institution that has regulation and supervise. And then you need an undertaking authorized by a competent authority of a member state to carry out the function of an AIFMD custodian. And the general compliance, an AIFMD custodian of an investment fund or an AIFM acting on behalf of an investment fund shall ensure that the same as it was done as if it was a local one. The sale and issue and repurchase, redemption and cancellation of equity interests of the investment fund, the value of the equity interests of the investment fund, the instructions of the investment fund manager, the transaction involving the sale of the investment fund assets, any consideration is remitted to the investment fund without delay. So it has the same conditions on it as a local custodian. Reporting obligations to the commission. The alternative investment fund manager has to report to the commission not later than 1 month after the end of the reporting periods, the following items. Every 6 months, by an AIFM managing portfolio of investment funds whose assets of manager in total do not exceed the equivalent of €1 billion. On a quarterly basis, by an AIFM managing a portfolio of investment assets that doesn't exceed 1 billion, and on a quarterly basis by an AIFM, which is subject to the requirements of each investment fund whose assets under management, including any assets acquired through use of leverage, exceed 500 million euro. And on an annual basis by an AIFM respect of each unleveraged investment fund under its management, which in accordance with its core investment policy, invest in non-listed companies and issuers in order to acquire control. The commission may instruct an investment fund to be audited by an auditor or submit audited financial statements to the commission. Financial statements must be audited annually and submitted to the commission within 6 months of the year end. And then they have notice of change. A regulated person should deliver to the commission within 5 days any information provided in its application, license, registration, or approval. Immediate written notice is required of the following, and that list is long. I don't know if I can find
That is a
section.
very long list.
And I left off some. It's long. I did leave off some. So immediate notice is required of winding up. That's normal. Or dissolution. Appointment of a receiver manager. That's understandable. Making of any proposal for the making of an arrangement with a creditor or creditors. Appointment of inspectors by a domestic regulatory authority or overseers. Bringing an action under the act against a regulated person or a subsidiary. Any change to the insurer. Any claim made by the regulated person against the insurer. Change in the amount of coverage. Any resignation or dismissals of directors, officers, or senior managers or senior employees. You have to advise them immediately if you're aware that any director, officer, or employee has been engaged in activities involving fraud or dishonesty. Any material breakdown of administrative or control procedures. This is a lot.
I feel like it's cheaper to just say you gotta report everything.
Yeah, because this is everything that you do has to be reported. So where the regulated person has reason to believe that it may be unable to submit a financial report or pay its annual fees to the commission, you got to write in for that. The failure of any bank, registered marketplace, clearing facility, or other entity with which the regulated person has deposited or to which it has passed money belonging to an investment fund or to the investors in an investment fund. Or if you become aware of a contingent claim, you have to let them know immediately. 10% of the regulated person's assets. Where the regulated person is the subject of any written customer complaint involving allegations of forgery, fraud, theft, or misappropriation of property belonging to an investment fund or an investor. Where the regulated person is associated in any way in any business or financial activity with any person who has been convicted of an offense punishable by 1 year or more in prison under the Bahamian law. Or you've been barred or suspended by regulatory authority, locally or overseas. Or where the regulated person is named as a defendant or respondent in any domestic or foreign criminal or regulatory proceedings. The first time I saw this list, I said, whoever is in charge of compliance has a lot of work to do.
Yep.
The commission
Any
may
sort of
review.
oversight.
Huh?
Any sort of oversight on these, I feel like it's a lot to maintain and keep up to date on.
Especially if you go back to the list of funds. If you work in an entity, let's see this one, Britannia. Britannia has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20 funds. And it's not, they will not hire 10 persons to manage 20 funds. Because you won't be making a profit. And I doubt they'll hire 8. So this is a lot of work to keep up with all of these requirements. There's a lot.
It's a lot for the commission too. I'm sure they have a huge department or multiple departments to maintain all of this.
But that's what I was asking you at the beginning, as to whether you knew whether or not they have actually recruited more persons in order to do these reviews, because the requirements that are set out in this legislation, they are onerous. They are very onerous. I know they had to make amendments to meet international standards.
Right.
But that is a lot. Let's go to the ICON. ICON is an entity, but it doesn't have a legal personality. It really is a contractual agreement. So this is another one of those civil structures that we have put into common law structure. And this is where 2 or more persons, they have agreed to pool their assets to establish an investment fund. The ICON hold assets in its own name. It can enter into legal agreements with other parties, and it can commence and participate in litigation once it is represented by an administrator. So if you look on that same list of administrators and funds, you'll see a few ICONs. Not many, just a few. I saw it just now. I should have remembered the
I do
name.
have one question.
Go ahead.
The point that it said that it does not have a legal personality, but then one of the other points state that it can sue and be sued in its own name. So technically, I mean, it's still separate from the persons who come together to set it up.
Yes. But they're trying to, don't forget that this is a civil creature. And so they try to put it somewhere in that company context, but not a company. Because you couldn't give it all the features of a company. Because it's not a company. And I think that's what makes it so difficult for people to understand what exactly is this. Because if you create an ICON, what can it do? What makes it different from a foundation?
Especially because it is registered. I mean, once they sign the documents, they do their certificate of registration or whatever it's called, certificate of establishment. And you file that at the registry. So it technically exists as its own entity. But I mean, like I said, the real question is, it states that it does not have a legal personality, but then it also has some aspects of having its own legal personality, because it can enter into contracts. It can be sued and can sue. So then I guess it's just the difference of its filing obligations and fees and other aspects. I guess it doesn't have like officers and directors per se.
No. Yeah, it's a creature, even I trying to wrap my mind around why is it necessary.
Like in this case, would there be, obviously there's no corporate veil because it's not a company, but at the same time it's private, but it can be sued in its own way.
But it's only between two or more persons. So it's like a contract. 2 or more persons have agreed to pool their money. So it's actually a contract.
Oh, right.
But because we're pooling our money, then it becomes an investment. Just by terminology. So we've all agreed to pool our money together, so we enter in a contract. And you have one common goal. Whatever that goal was that you agreed. So you could be established as a new icon and licensed as an investment fund itself. Or you could be converted from an IBC, a unit trust, or an exempted limited partnership to an icon, and then licensed as an investment fund. Or you could be re-domiciled as a company, investment fund, or partnership, and then convert into an icon, and then be licensed as an investment fund. They say even a foreign trust can change its governing law to the laws of the Bahamas, convert to an icon, and then be licensed as an investment fund. So the icon can operate one of 2 basic investment funds, open-ended or closed-ended. Open-ended means that you can redeem your interest in the fund upon issuance of a redemption request. And the closed one is you cannot redeem your interest in the fund. So how do you establish an icon? The governing regulations are not statutorily required to be filed at the Registrar General's Department, and is considered a private document which is not subject to public inspection as other constitutive documents. So the governing regulations must include the following provisions: the name of the icon, name and address of the administrator, the time period for which it will operate for specified time or unlimited time, the number of participation interests it can issue, the currency, the issuance of other classes or series of participation interests or classes, information regarding the administration of the icon, whether the icon will have a governing administrator or general administrator, amendment process for the governing regs, audit provisions, legal liability of participants, valuation of the icon assets, termination of the icon, and any other provisions required by the Investment Fund Act. You notice that provision there, the legal liability of participants. Going back to the same point when you made when you said it doesn't have no legal personality, it can sue. It can actually sue, but it's not a company. So because it's a contractual arrangement, there is a provision within the contract itself which speaks to their legal liability. So upon execution of the governing regs by one or more of the initial participants in the fund, the administrator will issue a certificate of establishment, which is sent to the Registrar General for registration. And the certificate will contain the icon name, the date of establishment, the name of its administrators, and the statement that it shall be licensed as a fund, and an address upon which it may be served for legal purposes. Within 90 days of the registration, the icon is required to be licensed by the Securities Commission or an unrestricted investment fund administrator as an investment fund. And of course, an extension can be granted by the Securities Commission. The administrator of the icon acts as its legal representative and is authorized to execute any and all contract, agreements, correspondence, deeds, and documents that may be required to be signed for and on behalf of the icon. So you understand now when they say it has no legal personality.
Yes, I see.
Because the administrator carries out that function. It should be noted that the acts of the administrator bind the ICON contractually and legally. The provisions of the governing regs and/or the act enable the administrator to exercise all powers, duties, and responsibilities that may be necessary for the administration, operation, and maintenance of the ICON. The ICON must have two administrators, a governing administrator and then a general administrator. The governing administrator is the operator of the ICON. They must be one of the following: unrestricted or restricted, licensed by the Securities Commission or the FCSB or under the SIA or under the BTCRA, or it could be a foreign entity with functions and powers equivalent to Securities Commission or the central bank. That's the governing administrator. A governing administrator is recognized as a director, a general partner, or trustee of the equivalent entity licensed as an investment fund. The general administrator must be an administrator licensed by the Securities Commission under a restricted or unrestricted license and acts as the ICON's administrator for the purpose of the Investment Fund Act. Both roles may be discharged by a single entity or two separate entities. As under the separate legal personality principles in company law, the debts, the liabilities, and obligations in conducting the business of the ICON are those of the ICON itself, and not of the governing or general administrator personally. I know this creature sounds very strange. In addition to his overall administrative duties, the general administrator is required to keep and maintain a register of participation interests, books and records of the ICON's operation activities, and accounting records for 5 years. So the minimum number of participants is 1, and there is no maximum number of the participants required under the Act. Of course, they could be voting, non-voting, redeemable. The ICON is statutorily required to hold annual meetings, as in the case of a company's company, which may be held in the Bahamas or any place in the world. However, unlike a company's company or IBC, an ICON may not declare or pay dividends on its interests or make distributions to its participants. Participants must redeem their participation interests in accordance with the provisions of the governing regs. Participants in the ICON must all be deemed non-resident for exchange control purposes in relation to their participation interests, if they want to be exempted from local taxes. Corporate and other entities in the Bahamas, such as the IBC, a company's company, a trust, an exempted limited partnership, foreign investment fund, they may convert from the existing legal form to an ICON, subject of course to the continuation provisions in the law. And an ICON may be voluntarily liquidated, provided it is solvent in accordance with the provisions of the regs. It may also be involuntarily wound up by a court if it is insolvent upon the request of the participants or petition by the regulator, or as the case may be, where the court finds it just to wind up an ICON. So if I were to ask you, if you were to make a presentation in another jurisdiction, and they ask you, what products do we have available for investors? How would you summarize it?
How would I summarize the ICON, you mean?
No, products. What products do we have in the Bahamas that's available to tourists?
Well, you could offer them any model of, depending on what they're looking for, any model of the investment fund, any investment fund model, or you can offer them the ICON.
Mm-hmm. Or
and then if you're speaking about investors, what else could you offer them? I mean, could you offer them a SAC, or is that completely separate?
No, well, the SAC would be with the investment fund administrator. When they actually open an account with a bank, they would open up SACs to separate the accounts.
Right.
Can they use a foundation?
Well, you can't really, can you, I mean, you can, I guess you can invest the assets of a foundation. But it's, but usually a foundation is for like a family or like for wealth preservation. It's not really like an investment fund where you can have multiple investors pooling, right?
Right. So if we go from the very beginning, when we started, we said we have companies that can be incorporated either under the Companies Act or under the IBC Act. And we know from the when we did part one that there are advantages and disadvantages under both. In terms of the cost, the regulatory filings, the commitments, all of the due diligence that's required for persons under both. But in doing part two now, we see that there are other structures that in some instances, they act like companies, but they are not companies. And they are being designed for either wealth management or for investment purposes. And we even have created companies that act as persons. And for those who wish to invest and manage their monies themselves, there is the PTC that has been created for that purpose. So putting all of those as the backdrop, I'm going to ask you the question now. Why is there so much pressure on the Bahamas related to these products?
Because it helps those who have a lot of wealth to preserve that wealth by not having to have their funds in their own jurisdiction, which then becomes taxable.
Okay.
And so it comes back to that question of, having your funds here. I mean, is there any sort of having your funds not in your jurisdiction of nationality is a way of you to preserve that wealth by keeping it secure somewhere else in a jurisdiction where it's not taxable.
Right. So you've seen where generations have changed, where young people are saying, I don't know why my grandparents put their monies offshore. I want my money here. And they have closed accounts. Countries that had amnesty, you've seen people close their accounts. They say it doesn't make any sense anymore because they have to declare. In most instances, the monies that they had in their accounts, they had to end up paying it to their tax authority. So that's one side of it. When you look at the pressure that's on the Bahamas and other similar jurisdictions in terms of taxation. But there's also an even greater pressure besides taxation, one that's there every day. And that is that these vehicles that we have designed are used for money laundering. That's one of the main reasons we attacked on a daily basis. That these things that we have created, they just attract people to launder money. So I know everybody knows the 3 stages of money laundering: placement, layering, and integration. And you don't need all 3. It could be either one. So in most instances, you would hear more than the taxes is that these vehicles that we have created are just tailored towards criminals who want to move money. And in particular, the IBCs. And so with all of that pressure, all institutions are required to do a risk assessment of their products and services and to put policies and procedures in place to mitigate against those risks. Because the products are so vulnerable to money laundering. So you know that the Bahamas in 2000 did their whole suite of legislation, a whole AML framework. And that's when they also introduced the IBC. So from 2000, there were a few amendments, but not until 2018 did the Bahamas then decide to write brand new legislation. Anybody knows why?
Because we were blacklisted. So we had
yes.
to try and
Why?
comply.
But why were we blacklisted?
Because there were, I guess, requirements that we weren't meeting. But no, that had something to do with, oh, I can't remember now. That had something to do with us joining something.
What's that?
Didn't it have something to do with us joining some other international organization or signing on to something?
You talking about beeps?
No, maybe I'm wrong.
You trying to remember?
But we were blacklisted before 2018, weren't we?
Yes, we were blacklisted practically
For
every
a very
year.
long time.
Yes. Okay, so what happened? What brought about this change? One of the major reasons was that the Bahamas missed a step. What they wanted the countries to do was they wanted you to find out what are the risks in the whole country from every sector. So they didn't want it just to be from the banks and the trusts and the securities business. They wanted every sector in the Bahamas, the risk. What are the risks in each one of those sectors identified? And then they wanted the Bahamas to widen the scope of what falls under the proceeds of crime, not just money laundering. So they wanted an all-inclusive document. And then they wanted people to be more accountable. And add to that is when they put on the wealth order, which means that the courts can then write to the banks saying, we need to find out where this person obtained this wealth. Give us the documentation. And so before time, you hardly ever see what you see happening today, where persons are being arrested and they're being charged under the Proceeds of Crime Act. So the Act says in Section 9, you commit an offense of money laundering if acting with knowledge or reasonable suspicion. Always remember that word reasonable. You either conceal the proceeds of crime, you disguise it, you convert it, you transfer it, or you remove it out of the Bahamas. It's a crime. If you make an arrangement concerning proceeds of crime, again, you could find yourself in jail. And here the act says that if you know, or you suspect, or you ought to reasonably have known or suspected that you have either entered into or you are entering into an agreement which facilitates, it doesn't matter how you're doing it, how you facilitating it. If it facilitates the acquisition, retention, and use, concealment of, or the control of the proceeds of crime by or on behalf of another person. That's how wide Section 10 is. It says if you know, you suspect, or you ought to reasonably have known or suspected. So it's not strict to say you know or you suspect. They added on reasonably have known. And then Section 11 says it's an offense of money laundering where a person knows or suspects or ought to have reasonably known or suspected that he acquired or he is acquiring the proceeds of crime, or he used it or is using the proceeds of crime, or that you possessed or possess the proceeds of crime. So you see how wide the legislation has become? And it's very wide when you also look at what they have stated in the act as what they call identified risk offenses. So it's not just money laundering anymore. It's corruption, cybercrime, human trafficking, financing of proliferation of weapons of mass destruction, terrorism or the financing of terrorism, and any other risk that the regulations will come up with. So the act gives you some ancillary offenses. Failure to disclose. It says, under this section, if each of the following conditions are satisfied, failing to disclose to the FIU or to a police officer that you know, you suspect, or you reasonably ought to have known or suspected that another person is engaged in money laundering or committing an offense related to an identified risk. That the information or other matter on which his knowledge or suspicion is based, or which gives reasonable grounds for such knowledge or suspicion came to him in the course of his business. That one does not make the required disclosure as soon as it is practicable after the information or other matter comes to that person. So you would see that persons who are in their own small businesses are trying now to get acquainted with what the law requires. Because this section which says failure to disclose, it covers everybody who owns a business. Because they said that if you have a suspicion, you need to inform the police. If you are a regulated entity, then of course, you know, you go to the FIU. But if you're just a regular business and you suspect that someone is laundering money, then you go to the police. Of course, the MLRO, if they know or they suspect or they have reasonable grounds for knowing or suspecting that another person is engaged in money laundering or an identified risk activity, they also have to report to the FIU. And when the MLRO decides that this is not a matter related to money laundering, they actually have to document the file as to why they think that it is not. And of course, tipping off is always an offense, and it still is one. Whether you know or suspect, and then you divulge that information to the client. So these vehicles that we offer to our clients, according to the OECD, these are products which are very vulnerable to money laundering, because they're saying that we are incorporating these companies We don't know these individuals, and they can be very useful to launder money. So what the Bahamas had to do was actually beef up its requirements for customer due diligence. What do we require as a minimum for a legal entity? Let me ask you, what do we require as a minimum for legal entities?
Well, you have to have like full due diligence. So any sort of information on its certificate of registration and what, you know, which country it's registered in, any sort of company bylaws or memorandum information on, you know, its directors, its officers, and if it's and probably shareholders depending on its role. So you'd have to have full information on all of them, depending on, like I said, depending on its role, you would need to have, you know, passports, proof of address. In some instances, you would need to have source of funds and source of wealth, which is showing where the money is coming from and how this person came to have those funds.
Right. So normally if it's a legal entity, you will have to get financial statements. You have to review the financial statements. Of course, you're going all the way back to an individual, whoever's the BO, but you still have to know if the company itself is making money and the jurisdiction and where they're from. So the act says that financial institutions have to identify the identity of the account holder. And they have to verify it by using reliable and independent source of documents, data, or information. They have to verify the identity of any person purporting to act on behalf of the facility holder and verify that such person is properly authorized to act in that capacity. So that's normally someone who has a power of attorney. You get the document, but you also need their ID information. Understand as appropriate and obtain information on the purpose and intended nature of the business relationship. And this is where we fall down most of the time. Because a person, when they first open the account, can say, today, I want this account open for investment purposes. Then you look down the line, 6 months or 8 months later, they're paying bills. Forget about investments. They're starting to liquidate securities. So what the act is saying is that you always have to make sure that the person is using the account for the purpose upon which they established the account. If they change it, and of course the documentation has to change. Identify and verify who's the beneficial owner of the facility. And if it's a company, you want all those that own 10% or more. And always be mindful of the qualifying of the percentage, because other jurisdictions have other percentages. The regulations state that the mandatory documents required by the financial institution to verify the existence of a facility holder. Simplified due diligence is conducted on accounts identified as low risk, unless, of course, there is a suspicion. And then, of course, you would do enhanced due diligence. What's the difference between simple and enhanced?
Well, simple is like basic is what is minimally required by law. And then
right.
You have to do enhanced, you have to show that you have proper procedures, you know, enhanced due diligence procedures. What do you get that's additional beyond what is required basically by law? What additional documents are you getting on these individuals or, you know, these entities to show that you know who these people are? In the case where you have any, you know, if there's any sort of high risk jurisdiction or, you know, anything that connects them that increases the risk surrounding that entity.
Right. So once you do enhanced due diligence, so let's take a company. A company is part of a very large structure. So you're going to have to go and get background information on those companies. What do they do? Who do they service? Are there any other minor shareholders? Then you would run background checks. on all of those individuals. And then you look to see whether there's any negative reports where they operate in other jurisdictions, whether there's any criminal matters on any of those companies or individuals. So enhanced due diligence is a lot more work and it is costly. So in addition to enhanced due diligence, there is also PEPs. So who is a PEP in the Bahamas?
That's like a politically exposed person. So somebody who has either holds a position themselves or is a family member of someone who holds a position in some sort of political office, whether it be, senior politician, judicial official, military official, like in the case of the Bahamas, like if you were on, commission of the RBDF, or if you were like, the prime minister of the Bahamas, those sorts of senior, those prominent like public functions.
Mm-hmm, mm-hmm. And so once someone has been identified as a PEP, it includes not just that person, but also the family members and their close associates. So whenever you accept a PEP, you have to look at what jurisdiction they're from, where did they obtain their money from, where is the money going to be coming from now that's coming into the account, and then what's the rationale for opening an account. And those same criteria used whether it's domestic or international clients.
Is it still once a PEP, always a PEP? Or is
No, it's within 12 months.
Yeah, and then some, okay, normally for international, you normally would look to see, or even locally, but more international, you look to see if that person is still active in the political arena. And sometimes they are not.
okay, so that
So you could have,
notice
go ahead.
has been done away with?
What's being done away with?
The whole once a PEP, always a PEP.
Yes.
Yes, yeah. Because if you do that, you'll have too many PEPs on your list.
Yeah.
And PEP is high risk. And a lot of banks don't want high risk.
Yep.
That means more policies, more procedures, more scrutiny,
Yep.
more reviews. It's a lot.
Yeah.
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 Also, I think the initial, as far as the trainings that we've had and the understanding that, we've had is that it was initially, like political positions at any time, like you said, once a PEP, always a PEP, and it could be close associates, but now it's only yourself or a family member. They took out the close associates and they took out the time that they instituted that time frame.
Okay.
Yeah, but our legislation still speaks to close associates.
Oh.
Some jurisdictions have changed. Still have close associates. We have not amended that.
I could have sworn that was amended.
It was when?
I don't know. I feel like that was changed for some reason under the rules. I think under the FCSP rules, I think it was. I gotta look at that.
The FCSP? No, now hold on now.
No, the
FCSP can't change, but hold on, the FCSP cannot change the AML rules.
No, that's what I mean. Sorry, I meant like the rules that they have to comply with, which is like the FTRA and the AML CFT rules.
I don't remember no amendments to those.
Okay, I gotta go look at all of that.
You sure?
I feel like there was some sort of change like last year. Or was it 2019?
I'm going to the laws of the Bahamas. And I am going.
I could be wrong. I just feel
No, let's see. Anyone else heard of it? Oh, they only have the old ones here. I have to go here.
Hold on, let me look.
on. Oh, come on. This thing is just jumping all over the place.
I had some issues with my internet today too. They cut off our power this morning, so when it finally came back on, the internet was spotty.
Yeah, just jumping all over the place. Hold on, let me see. No, not that, not that. Okay, not that. Okay, money laundering, let's see. I don't see no amendments here, you know. The BFSB only has 2000 and 2000 legislation.
Let me get back. Let me look into that. And next class, I'll have to see if I could find it.
I don't recall that, you know. Not saying you're not right, but I don't recall that. You say in 2020?
I thought it was 2019 or 2020. Let me see. Hold on.
In 2020 when we were all asleep?
No, it was really early on. Like, I feel like it happened in like November 2019 to about like February 2020.
So you're trying to say we were awake?
We were not locked in our houses at that time.
Okay. So let me see.
Oh, and Tessa, what's the act or the signing up to that we participate in that you were referring to earlier, the common like reporting standard? Is that what you meant? When the Bahamas signed up to CRS?
No, I couldn't remember what it was, but like she said, it didn't really have the change didn't really have anything to do with us signing on to anything. It just had to do with the OECD kind of cracking down a bit more.
Yeah, that probably was the BEPS, profit sharing, when we have to do all of these preferential this and beneficial ownership register here. And
Yeah.
But CRS was a thing that came in. I feel like that was something that I had to assist someone with recently. Like
CRS came after FATCA.
Or something. Yes.
Remember?
Yeah.
CRS came after FATCA. They waited for the US first to see how it worked. And then all the other countries then decided that, okay, it worked for the US, then we're going to do it too. And so all of the treaties that we had with all of the other jurisdiction in terms of when a country wanted to seek to obtain information from the Bahamas, they would have a treaty
right
between the two countries saying what information we would permit them to have and on what grounds we would permit or entertain your question. And normally was written around more or less somebody did something in their country, violated one of their laws. It was not specific to tax. And so all of those treaties had to be rewritten. And then now you see those countries coming back now because we've already sent two sets of communication. They're now coming back and asking questions on their citizens who had accounts in the Bahamas.
wow
I love how they're putting pressure on small countries like the Bahamas for their citizens' actions.
Yes, because remember now, we have been in this business from World War II. And the world has changed so much since then. And as far as they're concerned, because more persons are putting their funds offshore, there's less monies, less taxes that they have been collecting in order to support their own country.
My question is though, I have a question on, like, for example, a lot of people make jokes about like people who have Swiss bank accounts. I mean, I haven't seen anything really. I'm not sure what sort of policies Switzerland has. I mean, from my dealings with persons in Switzerland, it's a little bit more, I felt like it was a little bit more relaxed. So, you know, what are the standards that they have to meet up to if we have these offshore accounts, but apparently Switzerland has these offshore accounts and other jurisdictions too. Like I think it's Ireland. It is that has, what is it, like accounts kind of like that, where people like have off, like basically accounts in different jurisdictions. But like you hear about those places being blacklisted. I'm not sure what kind of standards they have for, you know.
Now, don't forget now, think about Switzerland. Think about when Switzerland started their private banking wealth. When was it started? You have to you have to use a historical aspect to answer all of these questions.
Yeah.
When did they start?
Long before us, I would assume.
Exactly. Where did the Germans hide their money?
But then when we started it, I mean, I guess you have to start somewhere. So you don't start right off the bat. But I guess you kind of had those foreign countries to follow as an example of like how they did it. So I guess as a younger country, are we looking at their models and kind of tailoring towards those, or are we kind of just winging it?
No. We didn't wing anything.
Because we're like following example, like different instructions from other countries on how they want it. And I guess we're following examples of other jurisdictions to kind of tailor what we need to meet the standards of.
No. We would have started out following the model more or less from Europe. And we started a long time ago. And we weren't the only country. Most small countries that are off the mainland were attractive to people who lived on the mainland. They wanted that security. Because most of those little small countries like us were small independent nations. So that's why they put their funds in these little small countries.
Right.
But time has evolved since then. And these people who had a lot of money were not paying their taxes in their country because their funds were made outside the jurisdiction. So if I had a business somewhere in the world, when my business made money, my profit went into my offshore account. It did not go home. And that's what they were looking at. Okay, we have all of these wealthy people, but our taxes is dwindling. We can't meet our current expenditure.
And then, of course, all the increase with, you know, money laundering and, like you say, cybercrime and all of this has come into effect. So now we're kind of trying to, I guess, meet these new to kind of counteract these new things that are coming into play.
Right. We're trying to stay alive. Because you have the taxation on one side, where a lot of people decided that, guess what, it doesn't make any sense leaving my money in an offshore bank, because at the end of the day, I have to pay taxes, so the net amount won't be worth it. Don't forget now, to have your funds offshore costs money.
Yeah.
Okay, so that's one thing. Then you have to look at it again. You have these big countries saying, all right, so you decided you want to create all of these different vehicles for to attract people to bring money to your country. But guess what? Your country is not any better off for it. You need to set up like every other country around the world. You need to find out who is really contributing to your economy. And you need to set criteria for that. So that was the next step that they came with. Put some laws in place whereby these companies have to then go through the whole motion to find out whether they're adding any value to the Bahamas and are they contributing to the Bahamas.
Have you heard a lot of information from the industry where persons are talking about people no longer like keeping their companies registered here, like this, like kind of moving away from this offshore system? I don't know if you've
at the very beginning, the general conversation was, oh my God, they're all going to leave. So far, no. But I'll tell you this, the legislation itself, in terms of being in compliance, the goalpost is far, far from where most of the clients are. But then you have on top of that now, all these registries. So it's like, you could not hit this list, but you could hit another list. So it's a, first it was just a competitive business with us fighting other small island countries. But now it's more than that, it's a matter of survival. Because without that second pillar, I think we'll have to learn to fish.
I know a lot of other countries like us had to start doing similar changes and practices. They had to start making changes.
Yeah. And we've been fighting back, but we haven't made any changes in terms of trying to find another industry. Yeah, that's the difficult part. What other industry can we go in where these 5,000 to 7,000 skilled professionals will be able to use their knowledge and experience? That's difficult. But all of the international pressures. And then you have to look at the next pressure that's on us now. We have Securities Commission just did their legislation. Other offshore jurisdiction, including private wealth jurisdiction, they passed theirs maybe 6 months ago, 8 months ago, and everybody's competing now for this new market that they said 2 to 3 years ago was not going to make it. There were no rules for it. They're going to shut it down. Now everybody is on blockchain. Everybody is moving money through technology. And again, we just trying to catch up, but everybody rode on a horse as soon as it can.
Right.
And to me, our people are not ready. Because we should have started from primary school the minute we heard about it. So people would have been ready either to fix computer, build computer, teach computer, write programs. How are we gonna get this market? When you have people in other parts of the world who can sit down and take a platform, sell it to other people, take a platform, trade. We don't have any of those skills here. If we do have it, they're at a very minimum. Because that's where everybody is moving to now. So that's another thing you have to look at. Do we have the skills now for this new offshoot of wealth management? Where everybody is doing their trading now electronically.
Right.
Just moving from paper here and paper there, that's out the window. People don't do that anymore.
I know. And it's the little things that make you think about it too. Like the other day, I went to the grocery store and the ATM wasn't even working. And it's like simple things that we haven't figured out yet. We haven't guaranteed to work yet. And now the world is still continue to move on and we haven't finalized the basics yet.
Yeah.
Or even a lot of small businesses here still don't even use credit card machines. You know, you have to do a minimum of $20 or they just don't have it at all.
Exactly.
And now we're moving towards this whole, like you said, blockchain, electronic, online stuff. And we haven't even done the basics. I mean, a lot of the banks are still trying to push people to do online banking.
And they refuse. The people refused. I think it was 2 weeks ago, 3 weeks ago, I told you all the people lying off outside the banks, and today they was the same way. They were sitting in the chairs in the hot sun.
Oh my gosh.
Waiting for the bank to open. This is around 8:30. They were literally sitting outside the bank in the chairs, waiting for the bank to open.
Yeah.
No. So again, I don't know where we would be in the next 10 to 15 years if our people are not ready.
Right. I mean, it would be great if we could start having small programs here and there that so that people can, I mean, I'm sure there are, you know, small programs where, you know, especially now that things are online, you can do these online webinars or seminars to start to get more familiar with these online systems, you know, how to create apps, how to, you know, how to, even basics, even for like persons who are more technologically, like people who struggle with technology, you could have basics where you show them how to do online banking, or you show them how to do these new online systems, especially for the older generation who struggle with it the most.
Exactly.
Bring them into the 21st century.
Now, everybody can't get to the 21st century, but you have to try.
Oh, I know. Yeah.
You have to try. So
I know one of the biggest things in the Out Islands is a lot of the banks were pulling out their banks.
Yeah, they did. They've already done that. They said that they weren't. Don't forget now, think about business. You have a company. You have investors, right? What are you looking for as an investor?
Profits.
You want profit, exactly. You want your dividends. And so when you see that there's a sector that's not making money, what do you think they're going to do? They're going to close it down. They're not thinking that, oh, there are 20 people on the Out Island. They don't have another bank to go to. Oh my God, what are we going to do about them? No, this is a business decision.
Mm-hmm.
So all of that you have to think about. I'm seeing right now an article, is 29 pages. It's called The Future of Wealth Management in Switzerland. 5 things private banks should do today. Develop strategic discipline. Learn to partner in the ecosystem. Focus relentlessly on client experience. Empower your relationship managers and increase organizational adaptability. And all to me, all of this is heading towards knowing technology, how to use technology. You see how difficult it was for us to start during the pandemic to put these children using iPads?
Yep.
The parents complain, the children complain. If they didn't have one where they were watching movies and playing games, they were lost. They didn't know what to do. When these children should have been smarter than us. I'm gonna look, see if I can find this amendment to the FTRR or FTRE.
Yeah,
I
I'm
don't
gonna look
recall
at
that
it
one.
too. Something to do with the PAPS and it's no longer being a close associate requirement. I'm gonna look at it. I could be wrong. I just want to. I feel like I remember something. I'm just gonna check into it too.
Okay. You could check and see. I don't remember it, but could be.
So this class today also covers that proceeds of crime and FTRA and everything. So
Yes.
next class will be on to what's the next one?
The next chapter
Company
will be
secretarial practice.
yes.
Okay.
Yes. Company secretarial practice. So if you're boarding a client from another jurisdiction, you have to get information on their tax requirements, because the law requires that you must have documentation that they are tax compliant in the country where they are domiciled. And I can tell you, when it first started, when the law first came out, it was like pulling teeth. The clients refused to give you that information. And once they were told that they could not be onboarded, they just plainly said, I can go to another jurisdiction. And then you see they waited 2 months and then they came back crawling. Because wherever they went, the same thing was required. So the law requires that every institution must conduct a risk assessment of their business. And so that's looking at your products and your services and ensuring that you have the right policies and procedures in place. And if you suspect that there is, or you have reasonable ground to suspect that there is money laundering going on, then the MLRO has to file an SDR. And of course, failure to file one when you should have filed one is a criminal offense. And when you file an SDR, the requirements are there as to what is to be completed. I noticed that in a lot of the conferences on AML, the annual ones that they have at ACAM, there's always a section on how to file an SDR. You have to be mindful when you write an SDR, you're writing which you believe is your reasonable suspicion. But you have to be mindful of the audience that you're writing to. Your audience is not only looking to see what triggered your suspicion, but whether or not your suspicion amounted to one of the identified risk offenses. So you can't say I have a suspicion. Suspicion have to be connected to one of the risk offenses. Is it corruption? Is it money laundering? Is it terrorism? And so you have to link those two things together for the FIU to make a decision. Should this go now to the financial crime unit? Or we should just acknowledge receipt and leave it up to the institution to decide if they want to continue the business with the client. In some institutions, they have their own, what they call their due diligence best practices. So some do ask for reference letters. You always have to get a copy of the passport, the utility bill. Sometimes you use the military cards for IDs. Sometimes you get the name and address of their bank where they do business. Sometimes they would give you a copy of their statement where the funds will be coming from. And so there are different ways in which you could satisfy that a client themselves is who they say they are, and that the source of funds, where it will originate from. So additional requirements for US clients, they have to provide some evidence that they've been advised of their legal and tax reporting requirements in the United States. And the same thing for Canadians. Most Canadians that come here, they decide that they want to live here for the rest of their lives. And so they close out all of their accounts in Canada. And they come and live in the Bahamas. Where there are closely and widely held companies, the ultimate BO is a listed company on a stock exchange, then you don't have to conduct so much due diligence. And the Securities Act give you the list of the exchanges that the Bahamas accepts. So where the ultimate BO is a widely held company, that's a company with 3 or more unrelated shareholders, and none of them have controlling interests. You need a copy of the prospectus, extract of the share register, the written confirmation from the lawyers or auditors, or you get something from Bloomberg or Reuters. For trust, if the BO is a trust at the very top, you get the full name, the home and business addresses, the nationality and occupation of the settlor, the beneficiaries, or the class of beneficiaries, and you also get it for the protector. The name and address of the trustee must also be obtained, and then copies of the passport of the settlor and the beneficiaries, and of course, statement of purpose for which the company is being established is also required. Then you have something called eligible introducers, and these are companies who would actually introduce clients to another bank, another institution. And of course, there still has to be some independent verification done by the local bank or trust company. And normally there is a contract between the two entities. And the AML framework allows for that, whereby you can request the minimal amount of KYC. And if there is a need for more detailed information, you can request the information from the eligible introducer within a reasonable time frame. And normally that time frame is stipulated in the agreement between the two entities. So provision of nominee and authorized signatory services. This again is another trigger by the OECD and other centers as another reason why our products are used for money laundering. They do not like these nominee signatories, nominee entities. So where the financial and corporate service provider is providing a nominee shareholder to a company, or if they're holding shares under declaration of trust, of course, they would have a nominee agreement or a declaration of trust document. And that's executed by all the parties. The ID of the ultimate BO must be known, verified, and approved, and information provided to the firm as required. So the FCSP has to make sure that it has all of this information. Where the FCSP is given a signing authority or any authorization with regard to his position as a director or an authorized signatory, the client has to complete a declaration of source of funds. And of course, provide all the information required relative to the nominee services, and of course, certified copies of the passport. A management agreement is normally done. That's for corporate director services. You have a fee agreement, and then you have a service agreement, and they have to be executed by both parties. An internal legal and compliance audit will be conducted on all client files on a quarterly and or semi-annual basis. And normally that's done on a risk-based approach. So normally if it's a high risk, it's once a year. If it's a medium, it's every 2 years. And if it's low risk, it's every 3 years. So notwithstanding the necessity or compulsion by law to do before such time and on a more consistent basis. In order to ensure that all clients have met the financial and corporate service providers KYC requirements and any statutory requirements that may be in existence at that time. So as an FCSP or as a bank or as a trust company or as an investment fund administrator, you have the duty to ensure that you know your clients. So when you see the nature of his business is changing, it is up to you to find out why it's changing, what is it changing to, and how does it impact the purpose for which the account or the relationship was established. Any questions?
No, ma'am, not from me.
And from you, Danielle A, Danielle Q.
Hey, yeah, I'm here.
Any questions?
No.
None from
Miguel.
None from
Okay.
Danielle Q. I have to go off and do some reading.
Oh, okay, all right. I'm gonna let Miguel send you all this article on Switzerland.
Was class canceled last week?
Yes, it was
Okay.
only Danielle Q and I.
Did you get my message why I wasn't there? I'm just realizing now, maybe, I didn't know if you knew that I had called to say that I wasn't going to make it. So that's why I thought we were I thought I had missed this section.
No, you didn't miss anything.
Okay, but I
It's
did
only me and
call.
Danielle.
You didn't get my message that I wouldn't be in the class?
No, but you're only one person. It was only me and Danielle. That's it.
Oh, no, I wanted you to know that I
Oh,
called
okay.
ahead to let you know, but I didn't want you to think that I just didn't show up. We had a death.
Oh, okay.
So
And I know Tessa had traveled.
yeah, so
Yeah.
sorry I didn't make it last week, but I did call.
That's fine. That's fine. Okay, I send it so Miguel could send this so you could get a better idea. I did a long time ago have a document on the history of of Switzerland. I'll look to see if I can find for you all. Oh, that could be hard searching for that. The history of well, you should know the history of banking in the Bahamas. Or you want to know the history of wealth management in the Bahamas.
Yes, can you send those?
I would be curious to read it. I'm not familiar
yeah.
with much
Okay.
of that.
Thank you.
Okay, I sent you the one on Switzerland. Let me see what I could find on wealth management in the Bahamas. I think it gives you a good perspective of who we are.
Thank you.
I think it put things in context. All right.
Thank you.
So next week is secretarial. Anyone in the class is a company secretary?
I am.
Oh, wonderful.
I'm a corporate administrator. I don't know if that counts as company secretary.
Well, anyhow, when we
Feels
go
like the
through,
same
you'll be
thing.
a corporate administrator.
Plenty weak.
Yeah, but what do you do?
I deal a lot with like company incorporations and company management.
This ain't the same thing.
No, secretary, you probably have a lot more duties
Yeah.
and
It's a
obligations.
this should be the one you should be aiming for.
I will keep that in mind when we discuss next week.
Yes, this is what you should be aiming for. Yeah. Because I've had classes before where I had students who were actually doing the job of a corporate secretary and didn't know.
No, I find this class so far has been really, really helpful. I mean, obviously I'm not doing a lot of what of these things. I mean, I do deal with different varieties of what we've been covering, but not in a lot of this is also up to the lawyers to, deal with. But it's good to have the basics and understand it on a deeper level.
Exactly. So even when you get things that come across your desk, you know why it is the way it is. And you can always ask a question. It won't be a dumb question because you have the basics.
Yes. Yeah.
And that's the key thing about when you do classes. You may not know, okay, I don't know, I should do step 1, 2, 3, 4, and 5, but I know at the end of the day, this is what it's supposed to be. This is the legal effect of this. So why are we doing this? What does that mean? And no question is a stupid question.
Yeah, I've enjoyed the class so far, and it's been a lot to understand, but it's good.
Yeah.
And
All
I
right,
like
so
that
let me
you
find
take an
out something.
application approach to it, like how it applies to the
Yeah.
and day-to-day business.
Right. It's easier for you to comprehend like that rather than just giving you names. And okay, this is this product, this is that product. But how do we use it? What is it used for? What is all of this? The ministers flying up and back and forth to Europe. Why are we changing all these laws? Why is everybody so busy digging in all of these papers? And this is the reason why we're fighting to survive our second industry.
Yeah.
Okay, right. And then at the same time, we need our people to start to strengthen themselves to be on par with other jurisdictions. So while we're fighting on one end, we're lagging behind at another end. Because we don't have those skills. What our clients are looking for. Our clients will no longer be people who are 70 and 80 and 90. Our clients are going to be millionaires and billionaires who are in their 20s and 30s. How are you going to service them when you don't know the first thing but going online?
Yeah.
How are you going to do it? That's the question you have to think about now with all of these products and services. Yes, we have these products and services, but there's a bigger movement out there in wealth management. where these people are moving their money across these technological chains and then they cash out and they bring it. So how do you then verify that this money is legitimate money? Then you don't even know how the process works. So think of those things. And I'll go see if I can find you the history. As close as I can on the Bahamas. All right?
Thank you.
All right. So I'll see you all next week. Same time.
Okay, see you then.
All right.
Okay.
Good
Enjoy your
evening.
week.
Night.
Yes, you too. All right.
Bye-bye.
Bye. Bye.